Preside for the oral argument. Would you like to reserve some time for rebuttal?
Yes, 4 minutes, please.
So noted, Madam Clerk. You may continue, counsel.
Thank you. May it please the court, my name is Ashley Richardson, and I represent Ms. Mushi in the appeal currently before you. The issue before the court is a very narrow one about the applicable statute of limitations at issue where an employee files an administrative charge with the Florida Commission on Human Relations and receives no notice from the commission within the 180-day investigation window. Under the Supreme Court's case in the year 2000, the Joshua case, the statute of limitations that should apply is 4 years based on section 95.113F. The issue we have presently is that the Fourth District Court of Appeal in its 2023 decision in Alou has reinterpreted that and applied a 1-year statute of limitations where the FCHR takes no action within 180 days. For this case specifically, there's 3 dates that matter. The first is September 22nd, 2021. That's when Ms. Mushi filed her administrative charge. She dual filed it with the EEOC and the FCHR. 180 days later would fall on August 21st, 2021, which was a Saturday, so the following Monday would be August 23rd. On August 25th, the EEOC issued its form notice of right to sue or dismissal and notice of right to sue, the right to sue letter.
In that case, counsel, could the trial court have taken judicial notice of the date the EEOC issued the notice of right to sue?
I think that it did. Because its opinion is based on Alou and notes that the EEOC did, in fact, issue some kind of notice. There was no discussion below as to the actual date of the notice or how that would have changed the outcome of things here. That just wasn't part of the lower court's consideration. Essentially, the trial court here followed the Alou decision and determined that Ms. Mushi's complaint, which was filed on, I don't have the date that the complaint was filed. It was filed more than 1 year after the EEOC issued its notice of right to sue, was untimely. It was March 5th, 2023. The Alou decision was issued on February 15th, 2023. So the issue we have here is that pursuant to 760.11 sub 8, which governs situations in which the FCHR fails to conciliate, that section was amended in 2020. The pre-2020 version is a single paragraph, and that was what the Joshua court analyzed back in 2000 when it issued its opinion. That provision states that in the event that the commission, which is defined by section 760.02 sub 2 as the FCHR and only the FCHR, says that in the event that the commission fails to conciliate or determine whether there's reasonable cause on any complaint under this section within 180 days of the filing of the complaint, an aggrieved person may proceed under subsection 4 as if the commission.
Did the FCHR make a reasonable cause determination in this case on appellant's complaint or notify the appellant of its failure to do so?
It did not. There was no notice received from the FCHR whatsoever inside or outside of 180 days. So under this pre-2020 version of subsection 8, it's just that single paragraph. The Supreme Court determined that the use of the word may in subsection 8 was permissive, meaning that an employee could proceed as if they had received a reasonable cause determination, but they weren't required to. And to liberally interpret the statute as a whole, as it's required by the language of 760 itself, the statutory mechanism, the 4-year statute of limitations, should apply. In 2020, which is sort of the issue here, in 2020 the legislature amended subsection 8 and added an A, B, and a C. The language of 8 plus A is the original section 8. None of that has changed, including the use of the word may. They did add a B and a C. Subsection B says, the commission, once again defined as the FCHR, shall promptly notify the aggrieved person of the failure to conciliate or determine whether there is reasonable cause. And then it adds requirements of what that notice must state. The notice shall provide the options available to the aggrieved person under subsection 4 and inform the aggrieved person that he or she must file a civil action within 1 year after the date the commission certifies that the notice was mailed. None of subsection B applies here. We're still under subsection A, which is the Joshua holding. Because here, the commission didn't issue a notice, and in fact, neither commission issued anything within 180 days, which makes this case a little different than several of the others we currently have pending before this court. Regardless, the FCHR wasn't the one that issued any notice, and the notice that was issued by the EEOC does not contain any information about Ms. Mushi's rights under the Florida Civil Rights Act or that subsection 4. So the notice doesn't comply with subsection B, the FCHR took no action within 180 days, it just doesn't apply. It's the same with subsection C, which just states that a civil action brought by an aggrieved person under this section must be commenced within a year. None of that is applicable here, so we're still under subsection A, which is the original version of subsection 8, which is what the Joshua court found the 4-year statute of limitations to apply to. So at this point, there's no reason, ALU just doesn't make any sense. In order for that holding to be applicable here, we have to read additional definitions into the definitions provision of Chapter 760, and we have to ignore these new provisions of subsection 8B that has all of these requirements as to what the notice might contain. So the ALU holding says that the notice from the EEOC should qualify as notice from the FCHR. There's no mechanism in 760 that would find that to be an accurate reading of the definition section. And quite frankly, the legislature saw fit to amend 760 in 2020 and add these additional provisions and essentially put an additional burden on the FCHR or requirement that they must notify an aggrieved employee that they failed to take any action within 180 days. But they didn't amend the definition section to include the EEOC or any notice that the EEOC might issue as triggering this 1-year statute of limitations.
Had the commission provided some notice at any point, then your position is that would have triggered the 1 year under the new provisions?
If they had issued it within 180 days, then yes, that would apply. Because the initial opening paragraph of the new amended subsection 8 still includes the within 180 days. So if this had fallen on day 181, we would still be under the Joshua provision where the FCHR failed to take any action within that 180-day window. So that, I don't believe, has changed regardless of the amendment to the statute. So we have the ALU holding requiring us to add a definition that the legislature didn't include into the definition section and also ignore subsection B of, well, I guess subsection 8B. Because the only way for the EEOC notice to trigger this 1-year statute of limitations is to ignore that the FCHR is the one that needs to issue it, and then it needs to include very specific guidelines for the employee as to what statute of limitations applies. Because if you look at the generic, I say generic, but it's the form notice that the EEOC checks the box on and sends to the aggrieved employee, it is only related to their federal claims. They have 90 days to bring those federal claims in whatever court they happen to choose to pursue them in, should they choose to pursue them. There's no reference to any state statute of limitations, the state law claims, or anything that would in any way alert an employee as to what deadline would be applicable.
Do you think we should reach all of this, or should this be resolved earlier with regard to whether the trial court should consider the documents on a motion to dismiss?
Oh, that was one of our concerns below, was that the trial court should not have considered all of those because of the notice of right to sue is not sort of a foundational document to the complaint. For example, like let's say there was a contract issue, and the Summerlin case that this court essentially looked at the exact same issue as to whether or not on a motion to dismiss it was relevant to discuss or actually attach the notice of right to sue to the complaint, and it found that it wasn't. It wasn't a foundational document necessary to bringing the complaint. So I think that I would argue that it's better served for a summary judgment motion, but the core issue is still the same regardless what statute.
Assume for the sake of argument that we agree with you that the trial could have used its discretion in denying your motion to strike the documents in question. Then what's your relief on appeal?
I'm sorry, what's my relief going to be?
Assume for the sake of argument that we agree with you, that the trial court erred in denying your motion to strike the documents in question. Then what is your relief on appeal?
We wouldn't need any. I think without the documents, we allege in the complaint that we satisfied all conditions precedent and exhausted all administrative remedies. So absent this additional looking to the documents outside the four corners of the complaint, there's nothing else really to argue.
But then again, would we reach the merits of the issue?
Not of this particular issue, no. That would, if we just go back to the motion to strike, we're just ignoring all of the sort of foundational stuff, and I suppose we would see you after the summary judgment motion was filed, because this is, That seems to be the state at which this issue is often decided. This is the first time it's come up in a dismissal. And like I said, based on Summerlin, the court did abuse its discretion, but I think the primary issue is really just which statute of limitations should apply. And it would be, I guess, our request that that issue be
Again,
resolved.
regarding the 4-year statute of limitations.
Yes, the 4-year statute of
Okay.
limitations.
Assuming the 4-year statute of limitations of section 95.113F, I believe, applies, when did the limitations period begin to run in this case?
In this case, I believe it's when it's 4 years from the time that the claim would be essentially perfected, for lack of a better word. So 180 days would be the starting of that clock. But even if we were to go back to when she filed her complaint, she still filed it timely within the 4 years.
And when was the case perfected in this case?
In this one, our argument is that that would have been February, let's see, so August 25th would have been the date. Sorry, I'm really bad at math. It would have been August 21st of 2025. So
And
we're
what
not
is
there
the-
yet.
What is the significance of that date?
That would be the 4 years from the expiration of the 180-day window. So we've given the administrative agency the opportunity to do what it is they're going to do. They don't do it, that starts our clock. Just like it would if they had issued a notice and the 1 year would start at the time they took some kind of action. Essentially, the period here would begin at the time where we have concluded that their action is available. So, I believe I'm into my rebuttal time now, so if there are no additional questions, I'm gonna.
Thank you, counsel.
Good afternoon. May it please the court. Paul Darajati on behalf of the Fraternal Order of Police.
So what do the documents show?
I'm sorry, sir?
What do the documents show? The documents that appellant wanted stricken?
The documents show exactly when the right to sue letter was received and when it was filed.
By the commission, right?
By the commission, yes, sir. Yes, sir.
So
Yes, Your
the
Honor.
appellant actually received notice.
Correct. Yes, Your Honor.
So the argument here in this court is we should pretend that the appellant did not receive notice.
No, I would submit to the court that the fundamental question before you is what actually is notice. If you follow the line of argument of the appellant, they're arguing that the EEOC can never be noticed.
I understand that, but tell me what those documents show.
The EEOC right to sue letter showed when the appellant filed her charge against employer and when she received her right to sue notice
From the commission.
from the commission. Yes, Your Honor.
So if those documents apply, which the trial court held that they do, there's no debate on appeal, right? She received notice from the commission.
Yes, Your Honor. That would be our position, that she received
The
notice from
state
the commission. I apologize.
The state commission.
She did not receive notice from the FCHR. I mean,
Ever.
we can agree on that.
All right.
The notice came from the EEOC. And the question that we're presenting to the court is what exactly is proper notice under the statute? And we would argue to the court that the notice, based upon the Alu case, which found its support in Woodham from the Supreme Court, that the EEOC right to sue letter can serve as notice under the statute.
Going back to the motion to strike, counsel,
Yes, Your Honor.
does the face of the complaint conclusively establish the expiration of the 1-year statute of limitations to serve as a proper basis for a motion to dismiss? And please explain.
Yes, sir. When we looked at the complaint, we saw that there was a time issue. And what we argued below is that based upon, in response to the Streighton Properties case, or excuse me, the Summerlin case, based upon the purpose of filing the right to sue letter, including that with the motion to dismiss in that case, it was distinguishable. In Summerlin, the defendant filed his right to sue letter for the purpose of pointing out that it was an incorrect basis for filing for a cause of action. Whereas under our position is that we're simply pointing out the procedural defect. The procedural defect comes from the law itself. The plaintiff has 180 days from the point they receive their right to sue letter.
Yes, Counsel, but here wasn't the date of issuance of the EEOC notice critical to the motion to dismiss, yet absent from the four corners of the complaint?
We would submit, yes, sir. Yes, we would argue it is critical because statutorily, the plaintiff would not have the ability to file her cause of action, her claim, which was filed on March 5th, 2023, probably about 500 days after she filed her original charge against employer. Under that circumstances, statutorily, she wouldn't be allowed to proceed under 760.11 sub 4. Our position was critical, procedurally, and we're not attaching something as the defendant did in Summerlin, debating whether the substance of the charge merited the right to sue letter.
Why didn't the appellee raise this issue in a properly supported motion for summary judgment as opposed to a motion to dismiss?
Our position was that under these circumstances, the defendant, where we can see from the face of the complaint that there was an affirmative defense, that we shouldn't have to proceed through the discovery process where it was vital to the plaintiff.
So can we address the argument that appellant is primarily relying on, it seems to me, which is the EEOC letter can't qualify as the trigger notice?
Yes,
That
sir.
only a right to sue letter from the state commission can trigger the one-year statute. Tell us why that's not accurate and why it's not contradictory to Joshua.
Yes, Your Honor. Under ALU, the Fourth DCA made the decision that a
Yeah,
right to sue letter.
Not under ALU, under the statute.
Under the statute requires that the commission issue some type of a notice. But the statute also allows a party to dual file. What they're essentially arguing is that under the law, the commission, or the EEOC, I should say, can investigate a charge against employer, but cannot issue notice on a charge against employer, which the Fourth DCA, when they examined that, it didn't conform to
I
this.
really don't want to talk about another DCA decision.
Yes, sir.
Let's talk about the statute and Joshua, which is controlling.
Yes, sir.
So I understand ALU might have been controlling below, but it's not necessarily particularly relevant here.
Sure.
Under Joshua and under the statute, tell me why you prevail.
Joshua is distinguishable from what we have here.
Right.
Joshua, the appellant in Joshua never received any notice at all. Whereas the appellant here, she received notice.
But the appellant relies on the plain language of the statute, A, B, and C, that talk about the responsibilities of the state commission to issue a right to sue letter, if you will, for lack of a better term. They didn't do that here, right?
We'd agree they did not do that.
Were they involved in the investigation at all?
It doesn't appear so. It
So-
appears that the plaintiff filed with the EEOC, and the EEOC did the entire investigation and issued the right to sue letter.
So the issue is, should we interpret the statute that talks about you may file within a year under A and apply that restriction, that statute of limitation from filing with a federal entity, EEOC?
Yes, sir.
And tell me again why that, we should agree with you on that.
Because the intent, the legislative intent in drafting this statute was to provide some type of procedural remedy, some type of procedural due process, as the Supreme Court articulated in Joshua. In Joshua, they were very.
The legislature defined commission, though, right, in the statute, and it defines it as the state commission, not the EEOC, right?
Yes, sir. Yes.
So isn't that the best place for us to look for what the legislature intended?
If we were to follow a stringent adherence to the letter of the statute, what we would end up with is a result that a plaintiff who has a charge against employer can determine his own statute of limitations. They could
So
file.
in other words, she knew she had a claim. She filed a claim with the EEOC. That claim was based, I assume, on federal law
Federal and state law.
and state law.
Correct. And if you file, what they're arguing essentially is if you file with the EEOC, you're going to get one statute of limitations, because what they're claiming is that the right to sue letter can never serve as a notice.
So tell us why you think the legislature's intent was to allow the EEOC letter to substitute for the state commission letter. And that's not a hostile question.
No, I think the best way is to look at the statute holistically. Had the legislature not wanted the EEOC to take part in this, they would not have allowed for dual filing when one files with it, either with the EEOC or with the FCHR. You can dual file, whichever entity has the investigation, does the investigation, and issues a notice, and thereby accomplishing procedural due process, which was the Supreme Court's concern in Joshua, thereby accomplishing procedural due process for the charging party.
And it's interesting, too, this 4-year statute, as I recall, a lot of tort claims now are controlled by a 2-year statute, right?
Yes, sir.
The whole statute of limitations regime was significantly changed by the legislature recently, right?
That is correct, sir.
So for wrongful death, those kind of serious claims, those plaintiffs are limited to 2 years, correct?
Yes, sir. Yes, sir.
But somehow this is going to be a 4-year statute?
If you follow the argument of the appellant, essentially what there are, fundamentally, they're asking this court to create 2 separate regimes as to where you file your claim. If you file your claim with the FCHR, you're going to be limited, assuming
They do the notice.
they do the notice.
Right.
You're going to be limited to 180 days. 1 year
1 year.
after the 180 days are complete. But if you file with the EEOC, it's 4 years.
Did Joshua apply a 4-year statute of limitations?
Yes, sir. It did. It did.
Getting back to the merits, please explain how we can accept your position considering the plain language of the statute, which requires notice by the FCHR and set forth the information that must be included in the notice, none of which were contained in the EEOC's notice to the appellant.
We don't dispute that the appellant did not receive a notice from the FCHR, and that the language of the EEOC's right to sue letter does not have all of the language that 760.11 sub 4 requires. However, if you look at Woodham, the Supreme Court case in Woodham, in that case, what the Supreme Court did was they analyzed how the language of the right to sue letter from the EEOC applies to 760.11 sub 4. And in fact, in that case, they resolved the split in the circuits. The fourth, the second, and I believe the third, the third, all had different opinions as to how to interpret the right to sue letter from the EEOC and apply it to Florida statute 760.11. There was never a question as to whether or not it was notice. It was just a matter of interpreting the notice to apply to Florida statute. So that's why I would submit to you that if this court follows the argument of the appellant, we're going to end up with 2 separate regimes where a charging party, before they even
They would just
file
file with the EEOC from now on, and then they would always guarantee themselves a 4-year statute of
Exactly,
limitations.
Your Honor, exactly.
And never have to bother filing the state claim.
And that
And
is,
totally circumvent the legislature's intent of establishing a fairly reasonable statute of limitations on these claims.
exactly, Your Honor, and that's what we're arguing to the
That
court.
seems to be an absurd interpretation of the statute.
And in the Senate notes to, and the House notes to the legislation, they specifically stated that their intent was to close the Joshua loophole
Right,
with
so
the
if we
2020
adopt the
amendments.
appellant's argument, nobody should ever file with the state agency. That would be malpractice. Because why would you do that? And lock yourself into a shorter time frame to file your claim?
Exactly.
Just file with the EEOC and guarantee yourself twice as long to file a complaint as people who have a wrongful death action, all kind of serious tort actions. You can guarantee yourself a 4-year statute.
That's exactly the outcome that we would end up with if we followed the argument of appellant. So,
Would the argument be the same if you have dual filing?
I apologize.
Will the argument be the same if you have dual filing, both FCHR and EEOC?
The argument would be the same, yes, sir. In this case, there was dual filing. The dual filing box was checked. There's no dispute over that. And
In other words, another aspect of it is, the argument by appellant is, the defendants ought to be investigated twice.
if you follow the logic of their argument, you would have to build up some type of regime between the EEOC and the FCHR where once the EEOC finishes their investigation, some mechanism has to get to the FCHR for
Well, they
them
can start the
to,
clock all over again,
it
right?
might start the clock.
But again, there would be no logical reason for anybody to file with the state entity if they can guarantee themselves a 4-year statute by just filing with the EEOC.
That is exactly correct, Your Honor. And none of this is written into statute. None of it's written into statute. It's just, it leads to what I would,
Must the
Argues.
FCHR conduct its own investigation if a charge is filed with FCHR under the statute?
yes, yes. That's my understanding. You file it with FCHR, you check dual filing box, they do their own investigation.
And there was dual filing in this case?
Yes, sir.
Okay.
Yes.
And is there any record that FHR conducted an investigation of the charge in this case?
I'm out of time, but just to
You may
answer your
answer the
question,
question.
there is no record of that. There's no evidence in the record that the FCHR took any action in this case. Thank you.
Thank you, Counsel.
I'd like to address that last issue. I'm not very tall. I'd like to address that last issue first, the issue of whether or not filing your charge with the EEOC is sort of the gotcha that would allow all plaintiffs to have a 4-year statute of limitations, and that's not an entirely accurate understanding of how the work-share process works.
Why not?
Because when a charge is dual filed and it's, let's say like in this case, when it's sent to the EEOC sends that charge to the FCHR and it's issued its own case number. So the FCHR is alerted to the existence of that case. They have every ability to put it on their calendar and say, oh, in 180 days, we need to send out a notice that says that we decided not to do anything with this case, or
But
maybe
they've already been told by the EEOC that they've investigated and did not find any cause to initiate litigation,
And
right?
if the EEOC sends that information to the FCHR is free to do with it what it wants. It can take the documents from the EEOC,
So
conduct
let
its.
me ask you to clarify that. So a person can file with the EEOC, solely with the EEOC, correct?
Correct.
Is that what occurred here?
No. You have three.
Your client filed with both.
Correct.
The FCHR referred it to the EEOC?
I believe that because it was initiated with the EEOC, they would then send the charge, just the basic information, over to the FCHR.
So she filed first with the EEOC?
That's where her charge was.
And how does dual filing agreement work?
So the work share agreement is just that. It is a work share agreement. It allows an employee to bypass sort of a more complicated process of having to file in multiple locations, and it also streamlines the sort of bureaucratic process of investigating these charges. But there is nothing in the work share agreement or the statute that says that that means that the decision will be shared, because these two statutory schemes, they arise from different sovereigns.
But she received a letter from EEOC, right?
She did receive a letter from the EEOC.
And did not file litigation within a year?
No, because there was no indication that she should. Because under Joshua and the applicable provisions of the new subsection
But in
8,
Joshua, as the appellee notes, there was no notice whatsoever.
technically here, the notice was outside of 180 days
So
as
you're
well.
asking this court to say that the EEOC's letter and the fact that she knew the EEOC declined to initiate litigation should be ignored and the plaintiff rewarded with a 4-year statute of limitations?
I mean, I
Because
think,
that's a reward, right?
I mean,
you're getting a 4-year statute instead of a 1-year.
I don't know that I would call it a reward so much as just the current
That's a
state of
lot
the law.
more time to file a claim.
That I'll agree with. It is a considerable
Right.
amount of
So
additional
isn't
time.
it true then that you're better off just filing with the EEOC so to ensure that you're never subjected to the 1-year time limitation?
No, because the FCHR it is notified of the case at the time it's dual filed. It
But I mean,
has the ability
But that
to,
occurred here.
it didn't occur, though, that the FCHR took
I
any
know they didn't get
action.
notice. She filed with the EEOC. It was dual filed with the state entity. She gets a letter from the EEOC. She sits on her rights and doesn't file for a year, but now she's entitled to a 4-year statute.
Yes,
That's your argument.
that's the argument, and we would argue that that's the current state of the law.
Under the statute, must FCHR conduct its own investigation when a complaint is duly filed?
No, it's not required to conduct its own investigation. In fact, neither entity is actually required to do anything, except under the new subsection 8B, in order to trigger that 1-year statute of limitations, the FCHR is required to issue some kind of notice that complies with the requirements of subsection 8B.
Once a complaint is duly filed?
Yes, yes.
And was that
Anytime,
notice issued in this case?
I'm sorry,
And was that notice issued in this case?
it absolutely was not.
And FCHR is required by statute to provide the notice?
Now it is. As of 2020, and according to subsection 8B, the shall is the word that's in that provision. So, all right, thank you.
Thank you, counsel, for your respective oral arguments.